That's what we're looking at this time. We're now being joined by the Attorney General and Commissioner of Justice, Rivers State, Chinwe Aguma, a senior advocate of Nigeria. Good morning and thanks for joining us.
Good morning.
This must be some kind of disturbing news for your state. Tell us how this is playing out now that you have moved to the Supreme Court, right?
Yes. Now, you see, it's playing out on two levels. There is the legal level, which is where I tend to focus as a lawyer. But there's also the political level, which we as lawyers try to contend with when we're in government. And at that political level, the general view of the populace that support the PDP is that they see the executive arm of government, the federal government, trying to use the judicial system to wrest power from a party that won an election. How to balance those two views is a tightrope everybody has to navigate to allow our democracy grow.
But you're a lawyer, so let's first of all look at it from the legal point of view.
Yes.
What exactly are the grounds upon which you're going to the Supreme Court? You don't agree with the ruling of the Court of Appeal?
Now, first and foremost, I am not going to the Supreme Court. Nyesom Wike, the governor of Rivers State, is. Mm-hmm. He is my employer. His job, my job depends on his. If he goes, I go. So, vicariously, I am going. Now, secondly, I am Attorney General of the state. I am not part of his direct legal team that is going to the Supreme Court. But I have followed the case from the tribunal down to the Court of Appeal, and as it is proceeding to the Supreme Court at this point in time. I don't want to approach it from the arguments that will be proffered at the Supreme Court. I would rather approach it from the legal concerns that would, as of necessity, necessitate an appeal to the Supreme Court. Before now, so many issues, legal issues, concerning election petitions seemed settled. However, the Wike case, and most of the cases, in fact, almost all the cases coming out of Rivers State, have created new legal principles that we find difficult to grasp or have conflicted with existing legal principles that have created uncertainty for a lawyer advising his client on what is the next course of action.
What are those issues?
Now, for example, we take the issue of this local standard and qualification to run the election. Before the decisions in Rivers State, Section 85(1) of the Electoral Act provides that political parties must give 21 days notice to INEC before they can conduct their primaries. Of course, this is pursuant to INEC's role of monitoring. Premised on that, a PDP senator in Kogi State had lost his seat to an AMPP senator because PDP did not give 21 days notice. In fact, the premise on that also, in the same Kogi State, a member of the House of Assembly had lost his seat. That was the law. 21 days notice was mandatory. And that 21 days notice was read from the day of whichever letter. So that if you give the first notice and you don't hold the primaries then, your second notice must be 21 days, the next one must be 21 days. With the decision in the reverse line of cases, you have two scenarios playing out. One, the 21 days is considered irrelevant. Another one is that the 21 days notice is continuous. Once you've done the first letter, you can keep writing and extending ad infinitum. You can change your dates as much as you please without giving the requisite 21 days notice. So if you walk into my office now to ask me for advice, if I go back to the first set of Kogi cases, Atai and Dangana and Adojo and Ochefu, Adojo and Ochefu, yeah. I would say, no, 21 days is mandatory. But if I want to rely on the new cases coming out of Rivers State, I will tell you, it's nothing serious. Now, the next case, the next line, the next problem that comes out of it again is this. Why the Rivers State cases are saying, why must PDP complain about it? The Kogi cases upheld the right of the other political party to complain about non-compliance with those notices, and in fact went ahead to hold that that complaint is both a pre-election and a post-election matter. So you could complain about it either in the High Court or at the tribunal with concurrent jurisdictions. So it will be good for Nyesom Wike to appeal so that the Supreme Court will take a definite stand on it. Because this Atai and Dangana case got to the Supreme Court. There was a tangential reference to this issue of 21 days, implicitly upholding the position of the Court of Appeal. But it will be better for us, all of us, to have a categorical, clear-cut statement, so that nobody goes about saying, oh, because they did not do this, therefore this wants to do that, they did not do that, you know, and eroding the confidence in the judiciary. That is one aspect. You go to the issue of Kadrida.
Which has to do directly with the election.
Yes, you go to the issue of Kadrida. You have conflicting decisions. Here in Lagos, Abaje and Ambode, the APC case, a five-man panel of the Court of Appeal, which is called the full court, the Constitutional Court, it's like sits as the Constitutional Court, says that there's no room for the Kadrida in the conduct of elections. Very clear. Rivers State case, five-man panel says that the Kadrida is located within the Electoral Act. So if I'm to advise you now, what do I advise?
So those are the grounds upon which
No, I'm just, they're not just the grounds. I'm showing you the difficulties in accepting the decisions. And you see, the funny thing about it is, the decisions now have a political coloration. Ambode case, Abaje is PDP. He raises the issue of Kadrida. They tell you that the Kadrida has no business in election petitions. That, in fact, the court went as far as saying that the Electoral Act predates the Kadrida. Therefore, there's no space for it, and it's not a basis for what they call challenging the election. Then you go here. PDP raises it against APC. I'm sorry, APC raises it against PDP. They tell you it is within the Electoral Act. So which one and how would you want to perceive it? And even yesterday in Ibadan, Ladoja against the governor Ajimobi, the Court of Appeal Ibadan decision also said that what is important, what is supreme, is the register, not the Kadrida, because Ladoja was also complaining about no use of Kadrida. So you start to see, you start to wonder, is a pattern emerging where, depending on the party that sues, a particular aspect of the law is interpreted in a particular way. I find it difficult to want to accept at this point in time, because I've practiced law all my life. I wouldn't want to believe that the legal profession will be twisted in this manner. And that is why I would support strongly that His Excellency proceeds to the Supreme Court, at least for tomorrow, if not for today. Let these issues be settled once and for all. And probably too, arising from these disparate decisions and different decisions, maybe too, this is a question of policy, an issue of policy. You find out that most of the cases are National Assembly elections, House of Assembly elections. The appeals end at the Court of Appeal. So that even if the Court of Appeal does not follow a Supreme Court decision,